Good morning, everybody. Welcome to the second in our series of 3 TCSP focused webinars. Last week, we talked about directors' duties and responsibilities being particularly important given the current economic climate and the resulting increased scrutiny that brings. In this context, today's topic, considering solvency and insolvency, is particularly important. When a company is solvent, a director has a duty to the company in the formation, promotion, and management of the company, generally expressed as actions in the interests of various stakeholders, and predominantly the company's present and future members. However, once a company is insolvent, or if insolvency is a real possibility, there is a change in the emphasis of the interests. Directors must, in exercising their functions, have regard to the interests of creditors who will be repaid from the company's assets. The duties, in effect, shift from members' interests to creditors' interests. So, in this regard, not only do you have to consider the solvency of your own business, it's important to assess the solvency of the companies for which you're providing directors' services. Hopefully, today's session will provide you with some practical tips for completing this exercise over the coming months. So, just some housekeeping for today. If you wish to submit questions, as usual, please do so in the chat function of the webinar or submit them to webinars@kpmg.co.im. We will respond to them during the webinar if we can, but if we're short of time, we will respond subsequently. The webinar is being recorded and will be available later today on our website if you wish to revisit some of it or to share it with your colleagues. So, for today, I'm joined again by Catherine Ridge and this week Aidan Tucker, both of whom are senior managers in our restructuring advisory team here at KPMG. We also have with us Ed Renton, who's a KPMG UK tax senior manager, and he's going to talk to us about interacting with HMRC over potential UK tax liabilities. I'm also pleased to say that Peter Clucas and David Doyle weren't put off by last week's experience and are here again today. Peter is the Managing Director and Head of Litigation at Cains, Cains Advocates Limited, and David is one of Cains' senior legal advisors, the former First Deemster and the author of a number of relevant leading Manx judgments. We all advise local TCSPs in a range of capacities, and it is some of these conversations that we've had with you recently that have driven this series. So we'll start today by asking Peter and David to just talk us through the legal interpretation of solvency. Peter, would you like to kick us off?
Thank you. There's a lot of legal academic commentary on the legal interpretation of insolvency. Professor Sir Roy Good, as recently as 2011, commented that, quote, "There is a remarkable dearth of English authority on the meaning and content of both the cash flow and balance sheet tests of insolvency. One leading textbook published in 2018, Macpherson and Key, The Law of Company Liquidation, 4th edition, devotes no less than 18 pages to the meaning of insolvency. So it's a complex area, and all we can do with the limited time available is superficially scratch the surface. Locally, a good a place as any to start is section 162 sub 5 of the Companies Act 1931, which provides that a company may be wound up by the court if the company is unable to pay its debts. During last week's webinar, I reminded listeners that the winding up provisions in the Companies Act 1931 equally apply to companies registered under the Companies Act 2006. Section 163 sub 1 sub 3 of the 1931 Companies Act provides, and I quote, "A company shall be deemed to be unable to pay its debts if it is proved to the satisfaction of the court that the company is unable to pay its debts, and in determining whether a company is unable to pay its debts, the court shall take into account the contingent and prospective liabilities of the company," end quote. Section 164 sub 1 of the same Act also refers to applications by contingent or prospective creditors. David, having said that this is an area of complex legal definition, are there any local judgments in this area?
Yes, Deemster Corlett in Irvings and Carters in 2017 dealt with inability to pay and stated at paragraph 249 of his judgment the following: Non-compliance with the statutory demand served under section 163 sub 1 sub 1 certainly establishes the court's jurisdiction to grant a winding up order, although clearly the court retains a discretion to refuse an order if it emerges, for example, that it's generally able to pay its debts as they fall due. Similarly, if reliance were to be placed on section 163 sub 1 sub 3, which may be said to import a modified type of balance sheet insolvency, it might be the case that the court might refuse a winding up even if a company's liabilities exceed its assets. Lord Newburger, the Master of the Rolls as he then was, in BNY Corporate Trustee Services Limited in 2011, stated, "In practical terms, it would be rather extraordinary if section 123 sub 2 was satisfied every time a company's liabilities exceeded the value of its assets. Many companies which are solvent and successful, and many companies early on in their lives, would be deemed unable to pay their debts if this was the meaning of section 123 sub 2. Deemster Corlett continues at paragraph 250 of his judgment. Section 123 sub 2 of the Insolvency Act 1986, that's the English Act, is in somewhat similar terms to section 163 sub 1 sub 3 of the Companies Act 1931, the Manx Act, and deals with the situation where a company is said to be balance sheet insolvent." Unquote. Coincidentally, the subsequent damages claim was listed before Deemster Corlett on Tuesday of this week, so log into www.courts.im for any future judgments. Returning now to past precedent, Deemster Corlett in Kalpthing, Singer and Friedlander Isle of Man Limited in liquidation in 2017 considered the definition of insolvent company in section 248 of the Companies Act 1931 and held in effect that whereas the company had surplus cash assets, it could not meet the total of its liabilities to discharge interest arising out of its contractual obligations to its creditors. The Deemster at paragraph 16 referred to the natural interpretation of the word insolvent and acknowledged that this somewhat simplistic view of the issue is greatly complicated by the case law. The Deemster held that section 248 applied to KSF-IOM and statutory interest rather than commercial interest was applicable.
Thanks, Peter and David. I think it'd be helpful to consider these definitions in practical scenarios. Let me use the example from last week's webinar as a starting point. First of all, the cash flow. Based on this simple cash flow at week 6, the SPV, without any other funding or overdraft, is not able to pay the HMRC liability of $3,000 as circled. So not able to pay its debts as they fall due. However, I hear you when you respond, that's not realistic and you have to look forward over a longer period. Or alternatively, you could forego the payment of corporate services of $5,000 in week 2 so that the HMRC liability can be paid in week 6. Or postpone as there may be rental income received subsequently. Hence, we're highlighting the need to have medium-term cash flow forecasts to allow you to assess the position of the business beyond specific type spots that may need to be managed. In the example, let's assume that from your discussions with the client, there's no prospect of any rental income whilst the pandemic in the UK is ongoing, as the tenant may have been made redundant or the commercial tenant is unable to trade. In 3 months' time, there is no cash available in the structure and corporate service charges continue to accrue. You may be comfortable with that position, given that the SPV owns a property and the balance sheet has a net asset position. However, it's always important to consider the realizable values, also take into account any associated costs. This can be quite easy to ignore when the accounts of the SPV are not being audited. Balance sheet considerations. In David's comments earlier, he mentioned balance sheet insolvency. My ears pricked up as the balance sheet's always the first thing I jump to when I'm looking at a set of accounts, not the P&L. I've included the same example from last week's webinar to consider further. As you recall, the SPV was holding a UK property book value of 250,000, financed by a loan of 200,000. On a reported basis, the balance sheet has positive net assets of 52,000. However, you're aware that there's no prospect of recovering the rental income debtor and that the value of the property has declined to 175,000. Looking forward at the estimated realisable value on a balance sheet basis, the liabilities exceed the assets by 33,000, and the SPV could be balance sheet insolvent. Combined with the inability to pay debts as they fall due with the HMRC liability, as previously mentioned, the solvency of the SPV is in doubt. We'll talk about the implications of companies continuing to trade whilst insolvent shortly. But first, I'd like to look at another point Peter mentioned, contingent and prospective liabilities of the companies. What do we mean by that? These are debts against the company which are not currently due, but may arise at some future time. As the name suggests, the debt may or may not occur and would arise upon an event which may or may not happen. This is different to a future liability which is binding on the company. Here's a few examples. Warranty claims following the sale of an asset, potential tax liabilities such as capital gains, possible damages arising from a breach of contract, e.g. a landlord's claim in respect of future rent and breach of covenants within the lease, and potential claims arising as a result of historic events, but as yet have not formally been notified or crystallised to the company. You may not be aware, but in a liquidation, rather than wait for a claim to crystallise, the liquidator can estimate the value of a debt that does not have a certain specific value because it's subject to a contingency or any other reason. Once valued, the liquidator then notifies the creditor of the valuation, which is then open to challenge. This can be useful when the only matter keeping a company in existence is due to an unknown potential liability. Whilst I'm talking about creditors' claims, in some SPVs, it's possible that you are the only third-party creditor. It's important to ensure TCSP fees are accrued. We've seen situations where the TCSPs have not raised their invoices, as would make the structure technically insolvent. This is particularly prevalent for property structures where there's an asset that is currently unrealisable, but still has value, but the structure has no cash, similar to the example I've showed earlier. A liquidator and/or an auditor may take a different view to the above, but if the services were incurred, there are reasonable grounds for a contract, and although the services have not been invoiced, the liability would still accrue and should still form part of your balance sheet considerations. So when you're considering the solvency of the SPV, you're looking at what were the assets and when were they last valued, the total amount of liabilities and how they're comprised. Is there any security? Are there any amounts owed to the directors? Do they have personal guarantees in respect of the company's indebtedness? The example I gave focused on one SPV. Aidan, what do you suggest if you've got hundreds of these SPVs? How would you approach it?
Thank you, Catherine. Clearly, there are many pressures on accounts teams preparing financial statements for TCSP's client entity books. Accountants and their teams can get caught up working on the smaller reconciliation aspects of accounts production, this creating delays in bookkeeping. The team may also delay postings and batch bookkeeping for efficiency, or be daunted by the need to create UK GAAP or International Accounting Standard quality accounts. And this again may distract from the need to simply post the cash book. Simplification of accounts production can help reduce the burden upon teams and enable regular balance sheets by the directors. This can be done using management accounts production, i.e. not GAAP standard accounts, so that a position statement can be prepared and reviewed with a focus on completeness of liabilities, as it's all too easy to focus on the assets you have rather than the liabilities of the company. When dealing with a large population of SPVs, there may be benefit in breaking down the steps of accounts production. For example, 1, cash positions, simply getting the cash books completed first, and preferably the whole population of the SPV book. Then 2, management accounting, using cash forecasting, and then balance sheet position reviews, followed by 3, annual financial accounting, potentially not to UK GAAP or international standard, as this is not always needed. Steps 1 and 2 will arguably keep the directors, and that is important, informed of the SPV solvency positions and focus the CSP accounts team at the same time. Breaking down the steps of accounts production and using their outcomes may well help improve and demonstrate financial controls in the CSP client book, heading off solvency issues before they arise. If you are a director of, say, 100 plus entities and cash books are not regularly maintained, there is an inherent risk within that book that there is a problem. Cash positions can be a great indicator. They should not be overlooked. And they are the bedrock of forecasts, management accounts, and indeed financial accounts. It is very easy to forget that the directors of SPVs are running and operating a live company with live transactions. Especially now, they need a strong understanding of their present cash position before allowing funds out of the door. The practicalities the TCSP industry face should not be underestimated. Access to basic banking data can be a significant pitfall for service providers. Practical issues can vary from simple delays in obtaining bank statements from both banks and all clients, the risk of unknown bank accounts or lending within the SPV, say for example from poor records transfer from a former CSP to potential for a nefarious action by the clients themselves. Slow accounting operations potentially highlight inadequate systems within the TCSP, from lack of knowledge in teams, or failure to flag and prioritize issues, or simply the team being under-resourced. Step 1 could be as simple as this: obtain a list of CSP client entities, stratify the population by out-of-date cash books or bank reconciliations, and investigate out-of-date cases. Watch out especially for cases where account services have been outsourced. Having assessed the cash or the balance sheet positions of SPVs and identified a number of where there are doubts, as a director, do you risk falling into a category of burying your head in the sand and not taking advice or action? How would this look if the company was placed into liquidation? Directors should be cautious about the prospect of trading out of an insolvent position. Their decisions should be well documented, and they themselves should be confident that the current and prospective creditor positions and creditors themselves are not made worse. We would always encourage you to seek professional advice. Why is this important, Peter? David?
Can I take that one? It's David Doyle speaking. It's important, Aidan, because these are frequently very complex legal situations with potential personal liability, with everyone trying to protect their own interests. And you need to be sure of your ground, as there may be personal attacks on you and on your personal assets. And to successfully repel any personal attacks, you need to show your client, your creditors, the regulators, the courts, liquidators, your insurers, and others that you took professional advice and that you acted reasonably. Moreover, if you take that advice and act on it, you can avoid the pitfalls and protect your position and the position of the relevant companies and trusts. Peter, last week we looked at directors' duties, at fraudulent trading and misfeasance and breach of trust. Are there any other specific areas of law in practice to look out for in insolvency or potential insolvency situations?
Thank you, David. I keep saying this, and we all keep saying it really, but it is to a large extent all about creditor interests again. There are three main areas which frequently arise in insolvent situations which highlight the regard which the law has to creditor interests. Firstly, I'll mention fraudulent preferences. In a potential insolvency situation, it's important to have regard to Section 250 of the Companies Act 1931. Section 250 sub 1 provides that any conveyance, mortgage, delivery of goods, payment, execution, or other act relating to property which would, if made or done by or against an individual, be deemed in his bankruptcy a fraudulent preference, shall, if made or done by or against a company, be deemed in the event of it being wound up a fraudulent preference of its creditors and be invalid accordingly. So the Companies Acts in this case prey in a bankruptcy law. Under Section 31 of the Bankruptcy Code 1892, the time period is within 4 months of the presentation of the bankruptcy petition. So in a corporate context, which is what we are addressing, it's within 4 months of the presentation of the winding up claim. Are there any cases on this, David?
Yes, in a Privy Council case last year, one of the issues in that complex Cayman weaving litigation was whether certain redemption payments were invalid as preferences and whether the money should be repaid with interest. The relevant local Cayman law provided in effect that every transfer of property made by the company in favour of any creditor at a time when the company was unable to pay its debts, with a view to giving such creditor a preference over other creditors, was invalid. Similar wording to Section 31 of our Bankruptcy Code 1892. It was accepted by the Privy Council in that case that on the authorities, the words "with a view" require a dominant intention to prefer, and that's paragraph 50 of the judgment.
Thank you, David. We keep on suggesting you take external advice, but I recognise that one of the difficulties is who's going to pay for that advice. If it is the company, and the company is possibly insolvent, is it appropriate to incur a fee and create another creditor? Could that in fact be a fraudulent preference? I think it's highly unlikely a court would criticise a director for reasonably spending company money on taking professional advice in respect of the company on a difficult potential insolvency. I draw an analogy with the approach of the court to asset freezing injunctions. Invariably, the court in those situations allows a sum of money to be released to cover reasonable legal expenses. So I think the court would condone directors incurring fees to take advice, but the court may expect the amount of money to be spent on professional advice to be proportionate to the size of the problem faced by the company. As I say, it's all about reasonable fees. Moving away from the payment of external costs issue, I'd like now to refer to the position in respect of floating charges. Section 251 of the Companies Act 1931 provides that, where a company is being wound up, a floating charge on the undertaking or property of the company, created within 6 months of the commencement of the winding up, shall, unless it's proved that the company immediately after the creation of the charge was solvent, be invalid, except to the amount of any cash paid to the company at the time of or subsequently to the creation of or in consideration for the charge, together with interest on that amount of the rate of 5% per annum. And finally, don't forget fraudulent assignments. The Fraudulent Assignments Act of 1736 provides that, and I quote, "All fraudulent assignments or transfers of the debtor's goods or effects shall be void and of no effect against his just creditors, any custom or practice to the contrary notwithstanding," end quote. I think I'm right in saying that that is the 1736 Act in its entirety.
Yes.
I always found this provision somewhat unclear, and given that this is the extent of what the 1736 Act has to say, again, David, is there any local cases on the 1736 Act provision which might help us?
Yes, the 1736 statutory provision was considered by Deemster Cain in re Higginbotham in 1999. Deemster Cain, as ever injecting some clarity into the law, stated that the expression fraudulent assignments or transfers in the 1736 Act must impute an intent by the debtor to assign or transfer his goods or effects fraudulently. There must be dishonesty. The question is, was the transaction bona fide, or was it a contrivance to defraud creditors? Importantly, Deemster Cain at page 72 of the law report construed the term present debts to include known and ascertained debts which are to fall due on a date in the future.
Thank you, David. Very helpful. I apologise for the fact that we're jumping around the Manx statute book a little, but we should not lose sight of Section 7, subsection 1 of the Companies Officers Disqualification Act of 2009. This provision, in effect, provides that if it appears to a liquidator or receiver that a person's unfit to be the officer of a company, the liquidator or receiver must forthwith report the matter to the Financial Services Authority. Unsurprisingly, liquidators and receivers are often more likely to criticise the conduct of officers in cases of corporate failures resulting in insolvency.
Thank you, Peter, David. I think it would be good to provide a brief overview of secured creditors and practicalities at this point, or arguably, in case of receivership, the impracticalities of having a receiver appointed. So what generally happens in a secured creditor arrangement? The response to securities greatly depends on the nature of the security. Securities are normally held by a bank on the SPV's tangible assets to support onward lending to the SPV. Security can be a simple fixed charge on the assets of the company, normally land and buildings, but not limited to these types of assets. Or a fixed and floating charge, which would normally include the land and buildings, but also other assets of the company, such as intellectual property. The latter charge may include additional contractual rights and powers to the receiver in managing certain aspects of the company's affairs, supplanting the directors. The primary issue for the directors is that a security may allow a receiver to be appointed to take charge of the income-generating assets or trade of the company on behalf of the security holder, whilst the directors remain responsible for the company's statutory and other creditor obligations. This means the company may lose control of its money-generating assets, yet still be responsible for the administration of statutory and accounting records, tax returns, and VAT returns, whilst not having the income to pay for those services and/or meet tax liabilities and other supplier liabilities. This could create a cliff edge in any future forecast that the company may have produced. It is unlikely that the security holder will be obliged to deal with those company matters unless specified in the security arrangement. In this scenario, directors can be cast adrift, clearly requiring protection from creditors and unsure as to their next steps. In other scenarios, say where complex client entity structures exist, multiple lending arrangements might be in place. This could be via intercompany lending between sister companies in a group, which may be underpinned by external third-party lending, for example, mezzanine finance. The rank and priority of secured lending then becomes a factor and can make worse the risks and conflicts for directors. Conversely, decisions of whether to appoint a receiver on behalf of one company over another when under common control or ownership can quickly become unwieldy and conflicted decisions. Mitigations are arguably to simplify the position, ideally by removing conflicts, seeking advice, and talking to key stakeholders and creditors. The most regular creditor will be tax creditors, most likely resulting from foreign tax liabilities. So what is an SPV's foreign tax obligation? It would be helpful to hear a legal perspective from Peter and David on how you should treat these whilst you're assessing solvency. But first, touching on an example of Catherine's used in last week's webinar, where there were potentially insufficient funds to pay the SPV's HMRC liability, it would be helpful to gain some insight on the practical dealings with HMRC, and we are joined by Ed Renton, a senior tax manager for KPMG in the UK.
Hi all, I work as part of our tax investigations team in the UK. We work with clients to get the best possible results when disclosing errors to HMRC or managing inquiries that have been instigated by HMRC. Most disclosures to HMRC will be made through their online worldwide disclosure facility. This consists of a fairly basic form detailing the number of years covered, the tax due, a brief description of the source of the error, and self-assessed penalties. HMRC are far more likely to be sympathetic to payment arrangements and penalties if an unprompted disclosure is made. You will need to think carefully about how the error occurred. Over the last 3 years, HMRC have been increasingly robust in their approach to behaviour. Indeed, we understand that training has been rolled out within HMRC aimed at increasing their scrutiny of how errors came about. If the error was a technical one, you should expect HMRC to ask about what advice was taken, and for HMRC not to take comments of innocent error at face value. HMRC are now very much more a show me operation, rather than simply a tell me one. Having someone disclose on your behalf can be helpful to tease out exactly how the errors came about and review what evidence you may have. For example, we've had a client who had a foreign bank account in her name for many years, and yet she had not returned any of the income. After talking things through with her, it transpired that a non-resident family member had set up the account and gifted the funds to her. Whilst our client's deceased husband was aware of this arrangement, she was not, and so she was found to have a reasonable excuse. It also helps to have someone who can explain to you why HMRC are asking the questions that they are, whether they're entitled to ask those questions, and what the consequences could be. HMRC will often ask for more information than they're strictly entitled to. One approach is to simply not provide the information, but the costs of fighting HMRC can be disproportionate. Generally, a better approach is to call the inspector and try and understand the risks that they're seeking to address, and discuss with them whether there is other information that can be provided that will address the risk. A collaborative approach is generally the best approach. The reason an error came about is important, as it not only affects penalties, which are now hideously complicated and can be up to 200% of the tax due, but they also affect the number of years that HMRC can assess, which can be up to 20 years where either no returns were filed or where the behaviour is considered to be deliberate. This is clearly very important if you're trying to work out what the potential contingent liability is. Once the disclosure is made, HMRC can then choose to accept the disclosure or carry out further investigations. To try and head off an investigation, we will always submit a covering letter along with the online form that outlines what happened and why. If you have a disclosure to make, or you're not sure how to handle a HMRC investigation, or just want a second opinion, we're more than happy to have an initial conversation with you at no cost. One particular headache for TCSPs can be the annual tax on envelope dwellings, or ATED. ATED is charged where a company owns residential property in the UK worth in excess of £500,000. Unlike tax on capital gains and UK source income, ATED is often considered to be a dry tax charge, i.e. there's tax to pay, but no associated income or gains with which to pay it. This can leave the TCSP in a tricky situation where it has a liability, but no funds in order to pay. The temptation in this scenario is to hold off submitting the tax return until the entity is back in funds. But what are the possible consequences of doing this? There are two potential penalty regimes that apply to submitting late returns. Whilst none of the penalties will apply if the entity has a reasonable excuse, a lack of funds to pay the tax due is specifically prohibited from being a reasonable excuse. The first of these penalties are the late payment penalties. There is an initial charge of 5% of the tax 1 month after the payment was due. There are then further 5% penalties at the 6 and 12-month dates if payment still hasn't been made, so a total of 15%. The second of the penalties are the late return penalties. Here, there is an initial penalty of £100 if the return is late, a further penalty of £900 if the return is still not delivered after 3 months, and if no return is made by the 6-month date, a further penalty of 5% of the tax due. If there is still no return after 12 months, there is a final tax geared penalty. This last penalty is probably the most important, as it is the only one that looks at the behaviour of the taxpayer. If you know that a return is due, but choose not to submit it, HMRC are likely to argue that your behaviour was deliberate. If HMRC prompt you to make a return, the penalty will be 35% of the tax due, and, possibly, naming and shaming. Therefore, let's look at an ATED charge on a property worth, say, 3 million. The charge will be 25,200. If the return and payments are delayed for 12 months, then, taking all of the penalties together, the total penalty loading could be in the region of 59% of the tax due. If HMRC deems your cooperation has been less than perfect, along with some other criteria, you could end up with the company being publicly named by HMRC. Therefore, we would always recommend that a return is made, and a call to HMRC's debt management banking is a follow-up. It's always easier to get a payment plan if returns are up to date than if there are tax returns outstanding.
Thanks, Ed, for that informative insight into the mysteries of the workings of HMRC. Sticking with tax-related issues, David, the traditional conflicts of law position is that no country directly or indirectly enforces the tax laws of another country. You had something quite controversial to say about that in a judgment a few years ago, didn't you?
Yes, Peter, I think you're making polite reference to my somewhat bold and pompous comments in Assessor of Income Tax and Homecroft Properties Limited in 2016, where I spoke in rather grand highfalutin terms of international responsibilities and cooperation with overseas authorities and the importance of paying tax and exchanging information, quoting at paragraph 64 US Supreme Court Justice Oliver Wendell Holmes in a dissenting judgment, where he said, and I quote, "Taxes are what we pay for civilized society," unquote. The traditional conflict of law position, Government of India and Taylor, is still general good law, I think. But I touched upon the international tax cooperation position in the Homecroft case.
You accept, though, don't you, that under the Judgments Reciprocal Enforcement Isle of Man Act of 1968, you would not be able to register and enforce in the Isle of Man a foreign judgment on a foreign tax debt. Even UK tax judgment debts are not enforceable here on the Isle of Man. I don't want to teach our grandfather to suck good old Manx eggs, but under Section 1 sub 2 of that 1968 Act, a foreign judgment under which a sum is payable, quote, in respect of taxes or other charges of a like nature, and in respect of a fine or other penalty, unquote, are simply not registrable or enforceable.
Small correction there, Peter. For the record, I'm not yet a grandfather, unlike some others I could mention, Mr. Clucas. And of course, I accept the plain wording of an Act of Tynwald in 1968. It speaks for itself. And I also accept that unelected Deemsters should not usurp the function of elected lawmakers. However, in a case known simply as A in 2017, in my former capacity as First Deemster, I gently suggested that the rule in Government of India and Taylor, dating back to 1955, even before I was born, it's that old, that in effect no country enforces the tax laws of another, may need to be revisited. I guess that would involve action by Tynwald or a judgment from the Appeal Division here in the Isle of Man or of the Judicial Committee of the Privy Council.
So, for now at least, foreign English tax debts are not enforceable in the Isle of Man via the 1968 Act. But watch out if you have assets in or if you travel to that foreign jurisdiction.
Wise advice. Consider also the UK Isle of Man double taxation agreement as amended only last year, and see in particular, it was Article 27, I think, from memory. Peter, I concur with your comments, and I have nothing useful to add to your points.
Okay, then, let's move on. David, can a foreign judgment debt be used to wind up a Manx company?
Oh, another question from Mr. Clucas, who seems to be relishing this opportunity to cross-examine a former Deemster. And I answer that question as follows, Peter. Yes. In a case known as Obiter in 2010, at first instance and on appeal, which you recently reminded me of, it was held that the 1968 Judgments Reciprocal Enforcement Act did not prevent reliance on an unregistered foreign judgment in the context of winding up proceedings.
Okay, I'm relishing this. A further question for you. Can a foreign tax judgment be used to wind up a Manx company?
Oh boy, you are asking some very difficult questions this morning, Mr. Clucas, and I'm not sure of the answer to that one, but wouldn't that be indirect enforcement of a foreign revenue law contrary to Government of India and Taylor as it presently stands? And you opened our exchanges with that reference earlier. And furthermore, Rule 3 of Dicey, Morris and Collins, a leading work on the conflict of laws, as adopted in Manx law, still in effect provides that Manx courts have no jurisdiction to entertain an action for the enforcement, either directly or indirectly, of a revenue law of a foreign state. Our appeal division, Judge of Appeal Heitner and Deemster Corrin in Re Tucker in the late 1980s, considered applications by a trustee in bankruptcy where the main outstanding creditor was the English Inland Revenue, although there was one further ordinary creditor. There were arguments that it was a tax bankruptcy. The appeal division held that an application by the trustee for an order to examine the noticed parties would be granted, as it was not an action to enforce a foreign revenue law. So even in 1988, Manx courts were arguably heading towards indirectly assisting foreign revenue authorities.
Okay, you'll be pleased to know that I've just one final question for you, David, and I want to bring you and our listeners back to 2020. How do you think the Manx courts might exercise their discretion in insolvency proceedings to take account of the difficulties of the current COVID-19 crisis?
Ah, the lovely topic of judicial discretions. I'm now on much safer legal ground. Manx courts have a wide discretion in respect of a winding up claim. Under section 165 subsection 1 of the 1931 Act, the court may dismiss it or adjourn the hearing conditionally or unconditionally, or make any interim order or any other order that it thinks fit. A good example is the case involving Ray Motors Limited, a well-known local company which was based in Ramsey. The claim form in that case was issued on the 1st of February 2017. I delivered a judgment on the 24th of October 2017 after a contested hearing that day. I had allowed a number of adjournments to enable negotiations to take place. In the end, there was no realistic alternative, and sadly, the company had to be wound up. Depending on the circumstances of future cases, the court can adjourn to allow time to pay or to consider a restructuring. Extensions of time or adjournments could be given. Each case, of course, is dealt with on its own merits, but let me give you a couple of specific recent examples in a liquidation context. In Short's Gardens LLP, Mr. Justice Snowden across the water in England declined on the 27th of April of this year to restrain liquidation proceedings based on anticipated COVID-19 emergency English legislation. That was the case where at paragraph 26, Mr. Justice Snowden expressed his displeasure at the submissions of a director, referring to the fact that amongst, and I quote, amongst a plethora of other meritless points, what a wonderful phrase that is, the director had taken another bad point. The judge was plainly not impressed, and that type of criticism every good advocate, and certainly those at Cains, seeks to avoid. In another case on the adjacent aisle, Mr. Justice Morgan, on the 2nd of June 2020, just last month, so the judgment is relatively hot off the press. The judge there, somewhat controversially, some would say, in effect enforced a ban on statutory demands before the English Corporate Insolvency and Governance Bill was passed. The court took into account evidence that COVID-19 had affected the tenant's finances, and that the presentation of the winding up petition by the landlord would itself be damaging to the tenant's business, even though any petition would be subsequently overtaken by the statutory ban. It is an important message to landlords. Speak to tenants. Give some commercial understanding in this present difficult climate. As we stressed in last week's webinar, open communication and cooperation is key.
Thanks, Peter, for grilling David, and David for that insight. Government of Taylor v. India. Sorry, Government of India v. Taylor. That takes me back to my insolvency exams a long time ago. So, last week we focused on directors' duties and responsibilities, and David gave some practical tips, a few of which I'd like to repeat given their importance. You need to check the financial information of cash flow of the companies upon which you're a director in order to monitor implications for solvency. We've discussed these at length during this webinar. Reviewing material contracts. Not only can these impact cash flow, they can also affect solvency. You should document your efforts to comply with your duties and reasons for your decisions. Where we sometimes see TCSPs fall down is not sufficiently documenting their assessment of why the structure should remain in existence. More often than not, there is a rationale, but often poorly documented formally in the minutes, and the financial forecasting that supported their view at that point in time is often missing. The benefit of hindsight can be their undoing. If in doubt, seek external advice, which is often overlooked but adds a layer of independent objectivity. We've also looked at the asset protection regime, the aim being to preserve companies' assets, ensuring value for distribution, and to protect interest of creditors generally. Where you have directorships over SPVs, the sooner steps are taken to understand and look at the best interests of those SPVs, the sooner you're able to understand any solvency issues, and then deploy appropriate responses. This proactive approach will protect your good standing. If an SPV has reached the end of its useful life or is no longer profitable and solvent, I'd encourage you to be proactive in considering directors' dissolution or members' voluntary liquidation. There are various costs associated with maintaining companies, both financial and time. I appreciate that these SPVs can generate recurring fees, but if you look ahead, would you want to be criticised for continuing to provide services when no one benefited but the TCSP and professional advisors? From a client's perspective, if the SPV is in a larger group, sometimes it's easier not to have to deal with it and keep paying the fees. Understand that you often provide services in-house, but I'd encourage you to consider independent liquidators where there are more complex issues such as dealing with overseas tax authorities or potential contingent liabilities. Where you don't have full knowledge of the history of the SPV, it's also helpful to appoint experienced insolvency practitioners. We are adept at reviewing the history of a company and unearthing forgotten about or hidden assets or liabilities. In the scenario where you've identified an insolvent SPV, it doesn't automatically follow that the company has to be placed into liquidation. You should consider whether there are steps that can be taken to refinance, seek a compromise, or renegotiate contracts. Again, seeking independent advice may protect you from criticism and potential action should a liquidator ultimately be appointed.
Thanks, Catherine. So, as we've heard today, Peter and David have highlighted that our local laws allow for some judgment in the assessment of whether a company may be able to pay its debts. So you need to ensure that you consider all relevant factors when making your own judgments. Reported net assets may not reflect the commercial reality of a company's position if it has contingent liabilities or if the realizable value of assets has significantly reduced versus the carrying value in the last financial statements. That was the point that Aidan was making about comparing and using management accounts rather than necessarily the GAAP accounting. It's important to keep good, up-to-date records in order to help you make the correct decisions at the right time, and this is done by regularly monitoring the position of the companies for which you act as a director. This may include producing short and medium-term cash flow forecasts, as Catherine referenced earlier. Assessing whether the payment of particular creditors may be deemed a fraudulent preference will often depend upon the particular circumstances. And Peter and David have highlighted that there are a number of areas of the law that may apply. So when considering which creditors to pay in a situation of potential insolvency, it's likely to be appropriate to take relevant independent advice. And Ed has told us all about HMRC and how they're viewing tax liabilities and effectively rewarding good behaviour. And HMRC can, in certain circumstances, look back 20 years and raise significant penalties. So you do need to be confident in the completeness of your historical tax accounting and compliance. Whilst technically they may find it difficult to enforce a foreign judgment for payment of taxes, as a director you have a responsibility to consider the creditor's interests. So hopefully we've given you some further food for thought today. I'd like to thank Peter, David, Ed, Catherine and Aidan for giving up some of their time. It's been extremely helpful to reconsider the law in respect of assessing insolvency, the practicalities of doing so, and some of the potential pitfalls that it is important to watch out for. As previously mentioned, if KPMG or Cains can help with any particular matters that you're dealing with, please just let us know. Seeking independent advice can help to demonstrate responsible decision making and may be cost effective in the long run. Please remember that you can submit any queries to webinars@kpmg.co.im and we'll disseminate them as appropriate. Thank you for joining us today. The webinar has been recorded and will be available later today on our website should you wish to revisit any of the points that we've discussed. And finally, next week, we'll be here again and we'll be discussing accounting for investments in our final webinar of this short series. Please do have a good week and thank you for joining us.